Hello, everyone, and welcome to Uncivil Law. And for today's story, we turn once again to the Karen Read case, which somehow continues to go on in the great Commonwealth of Massachusetts. Karen Read was accused of killing her boyfriend in a way that didn't really make any sense, and there really was no evidence against her. Yet the case continues. And in the revised trial, after the mistrial by the jury hanging, we are going to try to exclude, or the state is trying to exclude, some of the defense experts. We previously covered the state's effort to exclude the doctor with like 3 different board certifications who has 40 years in the emergency room about whether or not she can testify that these kind of look like dog bites. That apparently was a question we had to solve. But the state is not done with the stupid. They'd also like to exclude a witness who would like to testify about searches that were done or not, as the case may be, on a phone relating to how long to die in cold, which incidentally is a question that has yet to be answered in this trial. How long to die in cold? How long indeed? When will someone tell me? I don't know. But moving past that, we are going to read defendant's response to the Commonwealth's motion to exclude the testimony of defense witness Richard Green. Defense pissed. I don't blame them for being pissed, because the prosecution has their head up their ass about this entire case. So we're going to read the defense being pissed about, how like just because experts disagree doesn't mean that like they're not experts and stuff. Sometimes experts have different opinions. I know. It's amazing. All right, here we go. Now comes the defendant, Karen Read, and respectfully requests this court deny the Commonwealth motion to exclude the expert testimony of Richard Green as to his expert opinion that the Google search for how long to die in or how long to die in cold was made on Jennifer McCabe's phone prior to 6:23 in the morning on January the 29th of 2022. And his expert opinion that Jennifer McCabe's phone incurred user deletions of any data relating to Google searches. One of the possible people that might have some, what we say, guilty knowledge, right? Guilty knowledge, right? She knows things she shouldn't know. Is Jennifer McCabe. We have her potentially doing searches on her phone prior to a time when she should be doing the searches on her phone. Why would she be doing these searches relating to how long to die in cold? Unless she had some reason to do the searches, which means she was aware of the body being outside, which suggests that she has awareness at least. That means she's at least a witness, if not perhaps a suspect, because she has guilty knowledge. She knows things she shouldn't know. No, she's more involved than she's letting on in some sense. And this expert's like, I can use technology and science to show that she knows things she shouldn't know. Okay, great. So, but the Commonwealth is not really thrilled with it. Perhaps the Commonwealth just doesn't want to know how long to die in or how long to die in cold. Maybe they just don't want to know the answers. Who knows? And deny their request for an evidentiary hearing under the standards set forth in Daubert, which is the evidentiary standard along with Fry on the federal level. Fry and Daubert are 2 federal cases, which basically both say in so many words that expert testimony can be had as long as this person knows what they're talking about and it's based on a field that actually has scientific merit. And they use like scientific processes in coming to their conclusion and stuff. So as long as it makes sense, they can testify. Great. The Commonwealth has not made any showing the qualifications or methodology of Mr. Green do not satisfy Daubert. Instead, the Commonwealth's entire motion merely addresses the conclusions and opinions of Mr. Green, matters the court resoundingly state are subjects for cross-examining the jury, not the narrow function of Daubert. So again, just because the experts don't agree does not mean you get to exclude it, man. Right? This guy has done his homework. Is he qualified? Is he qualified? Is this a field of legitimate inquiry? Did he use standard methods to evaluate his work? Evaluate the work? Were his conclusions based on those methods? All right. And if you disagree with his conclusions, then you can get another expert to say, I disagree with those conclusions. Or you could cross-examine him as to those conclusions, as one does. And then the jury can figure it out because that's what they do. But just because he isn't giving the answer you like doesn't mean he isn't an expert. He might be wrong, but it doesn't mean he's not an expert. Okay? Moreover, as his opposition clearly demonstrates, Mr. Green is eminently qualified and methodology pertaining to the subject matter of the motion is reliable. As a result, in addition to denial of our motion, no evidentiary hearing is justifiable. I'll be very happy if they start deciding some of these things on the paper. That'll be fine. The motion of the Commonwealth to exclude from trial testimony Richard Green is just the latest in a Gatling gun, dystopian approach of the Commonwealth to deny Miss Reed the ability to present her defense through well-credentialed, methodological, reliable witnesses so she can have a fair trial against the baseless charges. Although, to be quite honest, I'm not 100% sure we need expert witnesses by Miss Green, or by Karen Reed. I mean, all we really need is Trooper Paul and just pointing them at the jury, right? But that didn't seem to work the first time, so maybe we do need expert witnesses. I'm not sure why we need expert witnesses. I'm not sure why just pointing pointing Trooper Paul at the jury wasn't enough, but apparently we need expert witnesses, so that's what we're going to do. The expert witness of the defense here, Richard Green, testifies as an expert witness in digital forensic in the first trial regarding the search of Long to die in cold. Existed in data of the iPhone of Jennifer McCabe with a timestamp of at or before 2:27 in the morning, which is like 3.5 hours before she should be able to do this. She shouldn't be able to do this for like 3.5 hours. She shouldn't know this yet. She knows it too early. Guilty knowledge. And in a deleted state without objection from the Commonwealth as to his qualifications or methodology. And for good reasons. Mr. Green has been accepted in several U.S. courts as an expert in digital forensic. The methodology Mr. Green employed in the first trial was the same methodology that proffered experts of the Commonwealth employ. It sure is. It sure is. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file, right? And by the way, here image doesn't mean photograph. Image means verbatim copy. Received the same raw verbatim copy of the iPhone, verified the hash signature value of the file, took the file and saved it to their computers, and then processed and evaluated the file with appropriate tools such as Celebrite, which then led to the exciting testimony or the exciting presentation by the state that Celebrite is not a sufficiently reliable tool, which comes as a surprise to all prosecutors pretty much everywhere. As prosecutors use Celebrite all the time, but this Commonwealth prosecutor is like, Celebrite's not that good a tool. It's not reliable. Okay, all right, sure. Fine. While Commonwealth witness Ian Whiffen used only the Celebrite physical analyzer and Artix tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using 4 of the same tools. Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite are now disconcertingly absent from her report submitted to the Commonwealth. Despite her admonitions in her prior report, it's best to use multiple tools. So she's like, in her prior testimony, she's like, cross-referencing multiple tools is best. And now she's like, all Celebrite all the time, which is pretty odd, but okay. Importantly, it was undisputed by all witnesses at the first trial that at 2:27 in the morning, a search artifact was indeed present on the iPhone of Jennifer McCabe after analysis using Celebrite physical analyzer tool that was available and on market at the time. It's thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as, and more comprehensive of that, of digital forensic witnesses. It is the opinion and conclusions, not methodology of the witnesses that differ. But that is not a Daubert-Ligon issue, and even if the methodology were different, it doesn't necessarily mean it's invalid, because different experts sometimes have different ways about going about things. There isn't necessarily one right answer for how to go about fixing a problem or addressing a problem. There might be multiple answers, but the question is whether or not what would a reasonable professional pick this answer? What would the reasonable man do? Except this time, it's a reasonable man who also happens to be a digital forensic expert. So what would the reasonable digital forensic expert do? And as long as they would pick one of these options, then any of them will be fine. And if you have a problem with that, you can cross-examine it as one does. What has changed since the first trial? The answer is disturbingly Orwellian, brings the prosecution closer to, if not squarely within, the danger zone of legal tyranny. I think we were already there after the shambles that was the first case, to be quite honest. After the first trial, the proffered expert for the Commonwealth, Ian Whiffen, a law enforcement-centric digital forensic consultant, appears to have gone back to his company, Celebrite, to have its researchers perform further updates to its physical analyzer programs such that the artifact containing the 227 timestamp has now suddenly disappeared from all Celebrite programs. Wow. Wow, that's amazing. The law enforcement expert who testified for the Commonwealth went back to work for Celebrite, and all of a sudden, all the Celebrite data says there are no artifacts. We don't know what you're talking about. That sounds a little bit like tampering with evidence, to be quite honest, but not the first time in this case. After Celebrite completely rid itself of the 227 search artifact that's incredibly inconvenient to the theory of the Commonwealth now comes before the court to say unilateral and unexpected Celebrite updates to remove the search artifact should control whether the jury is able to evaluate whose digital forensic theory about the artifact is more available. And in doing so, glaringly, the Commonwealth does not address other forensic tools, such as magnet forensic axiom, that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and still contains and shows the 227 search artifact, nor the several other digital forensic tools that Mr. Green used. Additionally, the motion of the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit, which is really strange when we're saying that this person is unqualified to testify. That's a bit strange to say that this person is unqualified to testify without one affidavit of support. Why are they unqualified? We think they are. Based on what? Reasons. Oh. Okay. Oh. All right. That makes sense. The motion does not even begin to meet the motion does not even begin to meet its going forward obligation to state how Mr. Green is now, suddenly after the first trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 227 search artifact, or why the methodology employed by Mr. Green is not reliable. Yet analyzing either of those things would be really helpful. He didn't use the right methods, Your Honor. He's a hack. He's a hack and he's not using the right methods. Okay, what are the right methods? Cricket noises. Cricket noises are apparently the right methods. Okay. Unless we're trying to determine the temperature outside, I'm not sure cricket noises are going to help. Maybe the crickets know how long to die in cold. I don't know. No one's asked them yet. To prevent the continued abuses of Miss Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's trial, the invasion of province to the jury, and other broader jurisdictional maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. For 3 years in this case, there's been no dispute over the methodology employed by the defense to address the 227 search artifact issue. On June 21 of 2024, Richard Green testified at trial that as a defense expert, without objections as to his qualifications or methodology, the use of digital forensics tools to analyze data on a copy of the cell phone data. As he stated in that testimony, after receiving the cell phone data contained on the phone, he used 5 digital forensics tools to evaluate and analyze the data: Celebrite Physical Analyzer, Magnet Axiom, Bella Soft X, Sanderson Forensics, SQLite Forensic Explorer, and ArtX. Through the use of these 5 tools, Mr. Green found the 227 search artifact existed and appeared to be in a deleted state. These findings are consistent with the April 24, 2023 report of Trooper Nicholas Garino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Garino reported that while the 227 search artifact did not appear on the version of Celebrite's physical analyzer he used for May 4th analysis of the phone, Mr. Green had used the then newest version of physical analyzer, which did depict the search artifact. Okay, so different things are showing different things, but that's fine. Inexplicably and unexplained to this day, Trooper Guarino did not disclose in his report the Axiom program he used at the time did show the search artifact. Well, that's really interesting and exciting, right? One of the troopers who testified for the Commonwealth failed to provide this interesting exculpatory information. The trooper failed to provide this interesting exculpatory information. Someone else is doing searches relating to this topic at a time when they're not supposed to be able to do that because they don't know yet. They're not supposed to know. Why are they doing searches? And he knows that because he knows it from his own stuff, but he doesn't put it in his report. How strange. How strange, man. Mr. Green's findings were further consistent across all 5 tools he employed and remain consistent with those findings as of January 2025 from analysis performed in the most recent versions of Axiom, which continues to provide the search artifact. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensics tools to analyze the raw image file of data from Jennifer McCabe's phone. Unlike Mr. Green, however, Mr. Whiffin used only 2 digital forensics tools in his analysis of the data: Celebrite Physical Analyzer, his company's tool, and Ardex. After performing the analysis on a then-on-market version of Celebrite, Mr. Whiffin testified at the first trial and reported that he had seen the 227 search artifact. Yeah. Thus, while he disagreed with Mr. Green's opinion about whether that information indicated a search for House Long to Die in Cold, he did not dispute that the search artifact was present and in deleted states. Jennifer Hyde also employed this methodology, originally using Celebrite Physical Analyzer, Sanderson Forensics, SQLite, Axiom, Ardex, and iLeap. 4 of these tools were amongst the 5 used by Mr. Green in his analysis. In her 2023 May report and her testimony at trial, Ms. Hyde agreed with Mr. Green and Mr. Whiffin that she had seen the search artifact. So it seems like a lot of people who are doing this examination are viewing this artifact. Now, they might disagree about what that means, but what that means, is, but a lot of people seem to see the artifact. They can see it. And so, that should be enough. She also admitted in her May 2023 report the 227 search artifact appeared in a deleted state. She disagreed with Mr. Green's opinion about whether this information indicated the search for House Long to Die in Cold was conducted at 227, but she did not dispute the 227 search artifact was present in her analysis. Inexplicably, Ms. Hyde changed her analysis and findings from her May 2023 report to align with Mr. Whiffin after Celebrite manipulated updates to one physical analyzer program, which the defense learned about approximately 1 week before trial began, magically removed the timestamp from records sourced from the Safari browser database. Interesting. They update the program and the data magically disappears. That's fun and exciting. Using only the updated Celebrite tool and no others, Ms. Hyde drafted a new report in December 2023, taking back, without explanation, her original conclusion that the artifact contained the 227 timestamp was present on the phone of Jennifer McCabe in a deleted state. She opined instead the artifact containing the 227 timestamp was not present in a deleted state or otherwise, citing a merely unsupported, conclusory, and scientifically inaccurate assertion the timestamp was not reliable. Yeah, like how did you come to that conclusion? Like Ms. Whiffin, neither Mr. Hyde nor the Commonwealth explained how the update occurred based on any scientific reason for the change. The Commonwealth simply makes the same bald, conclusory statements as Ms. Hyde, that further research shows the timestamp is not a reliable source for timestamp relating to the URL shown. The Commonwealth provides no explanation for the assertion, nor does it provide any information as to the reasons why their supposed research allegedly finds the 227 search artifact and this artifact alone to be unreliable. It also provides no information about how the methodology of the search or any other information regarding what changes were made, how, or why. Critically, despite the manipulation associated with this unexplained update, and the accompanying sudden change in the analysis of the Commonwealth's proffered experts. Ms. Hyde's second report, dated December 2024, does not provide a different methodology, but rather a narrowing of and changing of opinion about the presence of the search artifact. So based on no changes to the methodology, we changed our opinion. Why? Reasons unclear. In the second report, she employed the same methodology she did in the first trial, and Mr. Green, and Mr. Wiffrin employed, but deletes the mention of the inconvenient axiom tool she used in her May 2023 report, which is the date of this opposition continues to show the artifact at 227 in a deleted state in order to reach a different conclusion. It sounds a lot like the Commonwealth experts are manipulating their evidence, they're manipulating their reports, and they're even going so far as to manipulate the tools. You know? What the hell is going on in Massachusetts, man? What the hell is going on in Massachusetts? This is pretty messed up, man. The only difference, in fact, between application and methodology by the Commonwealth's proffered experts and application of the methodology by Richard Green is that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensics analysis. I'm not sure necessarily that's true, but it can't be like less thorough, one would imagine. The appropriateness and reliability of Mr. Green's all-encompassing methodology is evidenced by the fact that all the experts agreed and opined at some point during the first trial the 227 search artifact existed and appeared to be in a deleted state. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's important to use multiple tools so you can see the results from different sets and be able to compare those results and enhance with manual analysis. And that doing so is absolutely pertinent and allowing her to ensure that she's getting the most complete interpretations. This mimics the approach of Mr. Green and is counter to the myopic and company-based biased approach of Mr. Wiffrin, to which Mr. Hyde now disquietingly has morphed. The experts' disagreement is not over methodology, but rather there's opinions on whether 227 search artifact indicates the search "House long to die in cold" at or before 227. Contrary to the assertion of the Commonwealth, this is a paradigmatic battle of experts, which it certainly sounds like. It certainly sounds like to me, right? It certainly sounds like it's just a battle of experts. And I mean, I don't know. I mean, I haven't been looking into it. You know, if I were working this case, I would talk to a whole bunch of experts or read a whole bunch of material so that I could get up to speed and hopefully know what I'm talking about, or at least able to have a cogent conversation with an expert, right? If I'm not an expert and I want to become an expert, like what I would do is I try to read from multiple different experts, you know, so then I had a pretty reasonable idea of what I'm talking about. So it's like, I don't know whether or not using some or all these tools are good or whether it's bad or not, but it just sounds like a conflict between the experts and something you could raise in questioning about why different things make sense or not. Right. So that's how you do it. Okay. Let's read a little bit more from this stuff. How are y'all doing today, by the way? Happy to have you here. Thank you for the 382 of you currently joining me. I hope you're having a great day. I'm having a reasonably positive day. Life is not bad. Let's read some more. The Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face of two aspects of Daubert. The Commonwealth claims that Mr. Green is not qualified and his methodology is unreliable, but provides no explanation as to why. I mean, that alone just means you lose. I mean, you just can't like say things. You have to back them up, man. You have to prove your case. You have to prove your case. The case you're trying to prove at this point is that Mr. Green is not qualified. You can't just say reasons, man. There are reasons. In fact, the Commonwealth doesn't even describe the methodology of Mr. Green, which asserts it's unreliable and seeks to exclude. The Commonwealth's motion is not only bereft with respect to the two apparent prongs of Daubert, but also with respect to other aspects of the analysis. Nowhere does the Commonwealth discuss general acceptance of Commonwealth versus Davis or the 5 non-exclusive factors of Daubert. What little the Commonwealth does say about the law is rote and does not address the question here. The Commonwealth also fails to mention that Commonwealth versus Ritalana instructs the critical inquiry. For this purposes is where the proffered expert is qualified. I think so. The Commonwealth additionally misses the point of Daubert. It argues, for example, that Mr. Green's opinions as to the artifact timestamp lack any evidentiary support, cannot be made in good faith, constitute baseless claims, and have been debunked. These claims, in addition to being false, have no relevance in the methodological inquiry. Yeah, how are you drawing those conclusions? How are you coming to those? How do you know those things? I don't know. Broadly, Daubert inquiry involves evaluation of both qualifications and methodology. Right. Is this a legitimate field of scientific inquiry? Is this person sufficiently educated? Did they use standard methodologies in performing their task? That kind of thing. Did the expert do the expert stuff? Right. So we'll skip a little bit of the law. Okay. As to the critical inquiry of Daubert, the proffered expert's qualifications, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensic technician and more than 18 years of experience in conducting electronic data analysis and investigations. Mr. Green has been accepted as a digital forensic expert approximately 24 times in the United States. Mr. Green was qualified and testified as an expert for the first time in 1996 after spending approximately a decade working in computer information and networking, building a line of computers and doing computer repairs. Mr. Green started a digital investigation firm called United States Forensics, which he owns and operates. His company handles between 100 and 120 cases a year and receives annual inquiries for about 3 times as many cases. His company has worked on both civil and criminal cases across the country in both state and federal courts and on behalf of both the defense and law enforcement. He's a well-rounded expert. Since starting digital forensics nearly 2 decades ago, Mr. Green has worked full-time in digital forensics. In addition to being the company's president and founder, he performs the majority of investigations. He specializes in computer, cell phone, cloud, audio, video, metadata, surveillance, and other systems. Mr. Green has significant education, training, and experience. He held an associate's degree in digital forensics. Well, it's definitely good enough for Trooper Paul, right? He's a certified computer examiner with the International Association of Criminal Investigation Specialists and also holds computer-related crime investigator, cybersecurity, and computer forensic first responder certifications. He's also a member of 4 professional associations in the field of digital forensics and was a keynote speaker in electronic digital forensics at the National Association of Legal Investigators. Sounds pretty well qualified, right? You don't necessarily need any formal education to be an expert. You just need to have a basis for understanding what you're talking about, that you became an expert. So you can become an expert from on the job, and it sounds like this guy's been doing this a while, so it sounds like he knows what he's talking about. And if you don't think he does, then get someone else and say why that guy doesn't know what he's talking about. Get a different expert. But yeah, this is not the appropriate reading for appropriate thing for the court to step in. Over the last 18 years working in digital forensics, he receives on-the-job training. Namely, in addition to the work he does every day at his company, he participates in listservs, conducts research in the newest development of digital forensics, and attends training seminars at least once a week. In total, he's participated in hundreds of training events. He seems pretty qualified. We can kind of skip that. Contrary to the Commonwealth's contention in their motion, Mr. Green was not broad and vague during cross-examination. In fact, Mr. Green answered clearly and completely the only question the Commonwealth asked about his training experience and certification. Out of the 5 digital forensics tools Mr. Green used to evaluate the phone, the attorney Lally, we all remember him, chose one, Celebrite, and asked Mr. Green if he had certification for that particular platform. Mr. Green stated clearly, after seeking clarification of the question, that he had no such certification. He added his certifications are much broader, as they concern digital forensics fundamentals, how to conduct investigations, and which tool to use. His answers were specific and detailed. Yeah, he told you the answer. He told you the answer, but yeah. Just because he doesn't have the certification from the company saying that he knows how to use it doesn't mean it's not true. Curiously, according to the Commonwealth's own argument, Mr. Green remains qualified and his methodology is reliable in several other areas of data forensics, as he testified about during the first trial. The Commonwealth challenges none of those several areas of digital forensics, namely the call logs deleted from Jennifer McCabe's phone, the screenshot for the contact for Uncle Brian A. deleted from the phone, the location data from the phone, health data from the phone, location data from John O'Keefe's phone, and health data from John O'Keefe's phone. The Commonwealth does not challenge Mr. Green's certifications or qualifications, as these topics is further evidence of eminent qualifications. Yep, makes sense to me. The Commonwealth papers failed to identify a methodology for Mr. Green, let alone state why that methodology has failed. I mean, this is a real problem. Nevertheless, the Commonwealth now asserts that Mr. Green's methodology is somehow unreliable. What little support it provides is for ipsa dixa associations on issue for the jury, nice, and not on Dauber inquiry. The Commonwealth claims that Mr. Green admitted to this misinterpretation of data, caused Celebrate to update its physical analyzer program to remove the artifact. How deep does the conspiracy go, man? How's it go, man? Yeah, Celebrate is an incredibly popular tool for digital forensics. Celebrate is an exceptionally popular tool for digital forensics. So, yeah, this is, yeah. Okay. The Commonwealth also claims that Mr. Green's opinions lack any evidentiary support, cannot be made in good faith, constitutes baseless claims. First, contrary to these false and baseless assertions, Mr. Green's opinions are backed by significant evidence. An NIST scientific foundation review and draw on the very same data contained in the raw image file obtained by the phone were all three experts relied upon. Second, even if these experts were claims were accurate, the purported lack of evidentiary standard of the Commonwealth would go to weight and credibility, not the threshold question of reliability. I mean, this all makes sense, right? This is all just like completely on point. This is all just really, really like, this is all correct. It's like, why are we having this discussion? You know, this is one of those things that's frustrating sometimes as law. It's like, why are we having this discussion? I mean, because it's like, we all know the answer, but we have to waste time. It can be annoying sometimes, I'll tell you what. Oh, excuse me. All right, so is there anything more in this motion that I need to cover? Dauber evidentiary hearings are canceled in Massachusetts once papers in opposition to requests are filed demonstrating the lack of need for the hearings. This is another case that fits that proposition. The core concern of Dauber standard is promoting reliability by ensuring an expert has sufficient qualifications and employs a reliable methodology. This opposition establishes Mr. Green's eminent qualifications on subject matter in dispute and reliability of his methodology. The Commonwealth's bare conclusions, assertions of the contrary, are insufficient to warrant an evidentiary hearing. The Commonwealth's motions appear to stem not from genuine dispute over Green's qualification, but transparent and disquieting campaign to deny Reed the ability to present her own defense. I mean, really. I mean, the state's case is so weak. It is so weak. We're still waiting, incidentally, for the Supreme Judicial Court, as they prefer to be called. We're still waiting for the Supreme Judicial Court of Massachusetts to decide whether or not this case is barred on double jeopardy grounds. I mean, I think the answer is no, based on my best reading of the law. But then again, well, yeah, the Supreme Court of the state can either, of course, say my reading of the law is wrong, or also here's some new exciting law because of the Supreme Court of the state. So, you know, I think the answer is this case can go forward, as much as it pisses me off personally, because I don't think there's any case against Karen Reed, and I think it should have been dismissed by the judge in the first trial at the end of the people's case, because I don't think they can make the burden. But I don't think they're barred on double jeopardy grounds. But I am waiting, and we're all waiting for this decision to pop down so we can figure out what the answer is. So that would be nice. Yeah, as opposed to the Supreme non-judicial court. Yeah, that's why I'm like, what Supreme Judicial Court implies there's a Supreme Court that is not judicial. I don't know what that means, but some states do weird things. Maryland's Supreme Court wears red robes, which isn't ominous in any way. Yeah. By submitting conclusory and insufficient motion under the guise of Daubert, the Commonwealth seeks to force the defense to repeatedly participate in unnecessary motions and attendant resource in invasive mini-trials, thereby needlessly expending limited defense resources and diverting them from preparation. Although the most severe one is the formal dress of the Supreme Court of Canada. We need a break. So we're gonna laugh at the Supreme Court of Canada. Where is their oh yeah. Yep. Can I get all this on screen? Oh yeah. Okay, here's a picture of the Supreme Court of Canada. Okay. Yeah, that's fine. Sure. Great. All right, where are we? Through the misuse of Daubert, the Commonwealth is effective in obtaining dispositions of defense expert witnesses and attempting to lock in under oath their testimony for use or trial. This instant motion and others like it are tantamount to legal tyranny, not a search for truth and justice. Allowing Commonwealth's motion to exclude Mr. Green would not only sanction this misguided and disturbing approach, but also the impermissible and intolerable adverse jurisprudential Commonwealth actions of the Commonwealth actions, which would extend beyond the instant case. All right, so that's enough of the motion. Let's read a little bit of this guy's affidavit of Richard Green. Let's listen to Mr. Green say why he thinks he's qualified to offer testimony. Okay. Richard Green, so-called expert, provides the following testimony in the form of an affidavit. I'm the owner and president of US Forensics, a digital forensics company. I have more than 25 years of experience and 18 years of experience in conducting electronic data analysis and investigations. I've conducted thousands of investigations involving computer and cell phone forensics. My services have been retained by numerous attorneys across the country in both civil and criminal cases, offices of the public defender, and law enforcement. I've been qualified as an expert in digital forensics in numerous state and federal courts throughout the nation, including California, Florida, Michigan, Kentucky, North Carolina, Ohio, and even the Commonwealth of Massachusetts. The Commonwealth of Massachusetts. I obtained my associate's degree in digital forensics and computer investigation. I am certified with the International Association of Computer Forensic Examiner. I also hold the following certifications: computer-related crime investigation, a cybersecurity certification, and computer forensics first responder. I assume here, computer forensics first responder certification. There's two ways to read that. Computer forensics first responder certification. The one way to read that is that he does computer forensics with respect to first responder devices. That's probably how that's supposed to be read. Another way of reading that is that he is himself a first responder with respect to computer forensics. So he's the 911 of computer forensics. He will charge into the building with his laptop in hand, man. He fears nothing. I'm also personally licensed to operate a private investigation agency, which is a requirement in those states. Not every state requires licensure for private investigators. These states apparently do, but he's a PI. Nice. I'm presently a member of the following professional associations. Throughout my career, I have kept current with developments in electronic data analysis, including computer forensics. A partial list of events that I've attended over the course of the last 7 years includes a whole bunch of things. Training by Belkasoft, Celebrite, Heridex, Magnet Forensics multiple times. Magnet Forensics apparently really likes the training. Belkasoft, Celebrite, Detego Forensics, Magnet Forensics, Celebrite, Cellhawk. He's been to a lot of trainings, man. USF was initially provided with Celebrite report prepared by Trooper Nicholas Garino with the Massachusetts State Police, which was labeled as a full file system extraction of a phone. An initial report prepared by the trooper, the search for House Long to Die in Cold did not appear. Recognizing this report is not the best evidence, and I'm not sure whether or not he intends to use the phrase best evidence in its legal sense. But if he does, bonus points. It's not the best evidence. The best evidence is the original. The best evidence is the original or as close to it as you can get. So, you know, we don't want a report about the thing. We want the thing. You know, we want as close to the original as will be provided for us, right? We don't want testimony about the videotape. We want to see the videotape. You know, ultimately we want to see the videotape, right? We can have some testimony about the videotape, but ultimately we just want to see the thing, man, rather than have someone tell us about it. So that's best evidence. And he's right? The trooper's report is not as close to the original as you can get because we still have the cell phone. The cell phone is the best evidence by definition because it's as close to the original as you can get. I subsequently received a USB drive containing the image, and again, image here means copy of the data, described as J. McCabe belonging to Jeffrey McCabe, which was forensically copied by the Massachusetts State Police using a tool known as Gray Key. The USB drive containing the forensic image was sent to USF, that's to my company, by the Assistant District Attorney Lally by way of the trooper with the Massachusetts State Police. Upon receipt, the image containing the copy of the phone was assigned an internal evidence number. Oh my God, are you telling me they must not be a very good company? They must not be a very good company. They use evidence numbers and they have evidence logs and they know who dropped off the evidence. They kept a record of who dropped off the evidence and when, and then they gave it a number and assigned it in a log. They must not be a very good forensics company. Why would they do any of those things? Why would they do any of this thing? Oh, Lord. Notably, the USB drive containing the forensic image of Jennifer McCabe's cell phone failed to include the associated documentation containing the hash value, which is a well-known mechanism to validate data. After personally insisting they provide the hash data associated with the data, they're initially provided with a PDF containing the hash value and its listed value within that PDF mentioned the image key. That's definitely the most efficient way to provide a hash value, a PDF. After obtaining the full file system extraction, the data was processed and analyzed using various tools. Oh my God. I know they didn't use red solo cups. They didn't use red solo cups. No magic ping pong ball. They don't appear to have even once flipped a video. They don't appear to have even once removed video data. Yeah. It is my opinion, based on a reasonable degree of scientific certainty, the user of Jennifer McCabe's phone searched House Long to Die in Cold at or before 227. In my professional experience, an analyst of a device's internet search history often gives valuable clues. for knowledge or intent. In this case, knowledge being more the key. How did you know to conduct that search? How did you know to conduct House Long to Die in Cold? How did you know to do that at 2:27 in the morning? How did you know these things? You're not supposed to know these things. You knowing these things is guilty knowledge. What aren't you telling us? You know more than you're supposed to know. I conducted a review of the search history obtained from the phone and observed the following significant artifacts for the morning in question as reported by Celebrite. Search term House Long to Die in Cold, date and time 2:27, source Safari, state deleted. In Celebrite Physical Analyzer, House Long to Die in Cold searched not only up in web history, but Celebrite further refined the results and included it in the searched items artifact section. It was marked as a deleted record with an adjusted last viewed timestamp at 2:27. Noting the inconsistencies in Celebrite reporting between one report and another report, I contacted Celebrite technical support to inquire if they could provide additional information. Celebrite technical support staff indicated they believed the artifact was reliable and no issues had been brought to their attention. On April 22nd, 2024, the Commonwealth expert Ian Whiffen emailed me saying the last few times showed in the PA will be getting removed from the artifact in the next available physical analyzer. That's so funny, man. They're manipulating the tools, man. They're manipulating the tools. Shortly after the trial, Celebrite released its analyzer tool, which also removed the timestamp. Notably, Celebrite is the company that markets itself as providing digital intelligence solutions for law enforcement and is used by over 6,900 agencies in 100 countries worldwide. Although I'm aware that Celebrite recently changed its analyzer program so it no longer reports on timestamps of this particular artifact, I have not misinterpreted the data. In other words, Celebrite be lying to you, though. In other words, Celebrite be lying to you. Lisa Buckley says, you make me laugh so much. So happy to see you back on This Much Love. Yeah, I mean, we do cover it from time to time as there's developments. We do cover it from time to time as there's developments. And Karen Read, the trial is a pit of stupid. It's a pit of stupid. And I don't know what's going on. It's hard to believe that there could be anyone who has so much influence that the prosecutors like that scared of them. What bodies does someone know where there's buried, man? I mean, damn, And we appreciate our UK friends. We like our UK friends. You were kind enough to give us our system of law. And then you kind of abandoned it a little bit, but it's okay. We still like it, even if you guys don't as much anymore. Lol. Do you remember when the UK had freedom of speech? Pepperidge Farm remembers. Axiom is an application product offered by Magnet Forensic, which is a competitor of Celebrite. Best practices in digital forensics require forensics examination to view data and artifacts with more than one tool. Therefore, I also processed using Axiom. Axiom reports the 227 artifact. Shortly thereafter, I contacted Magnet Forensic technical support to see if additional information could be provided regarding the artifact. I was advised by technical support that 227 timestamps indicate the search would have to occur before then. Well, no shit, right? I mean, the timestamp would have to be the latest time it possibly could occur. Since my initial analysis, USF has upgraded to the more advanced Axiom Cyber Physical Analyzer, which was released on December 17th. This version of Axiom continues to report the above artifact with even more precise last view time in Safari suspended time. Moreover, Axiom's user manual describes the artifact as follows. Safari suspended state tabs, last interaction, the date and time of the current tab state when it was last interacted with. This date and time will be reflected when the user is last interacted with the tab in Safari or if tab auto-refresh on local device only. In order to validate the timestamp, I looked at numerous examples of web sessions on Jennifer McCabe's device, including URLs containing Raining Men, Canton MA, Hako Mock Sports, and Eastern Bank. In all those instances, the browser state DB appears at the end of the stream. It's consistent with how Magnet describes the artifact. In order to confirm the accuracy of the search event as reported in the Celebrite Physical Analyzer and consistently throughout multiple versions of Axiom, I then independently performed a low-level analysis of the artifact. The particulars of the artifact are as follows. It is my opinion, based on a reasonable degree of certainty, the house long to die in cold occurred at or before 227. And then he goes on to say, it's my opinion the search artifact was deleted either by deliberate user interaction or manual post-imaging manipulation of the data. So someone deleted it on purpose. I mean, you know, so then he goes through like how that would occur and talks about that in a scientific way, where he talks about that. He talks about various anomalies. So, I mean, you know, he seems like he did his due diligence and he seems like he knows what he's talking about. He seems like he's got it. So, you know, yeah, seems like he's got it. So I think he should be allowed to testify. I'm not sure why the state is so salty about this. Well, I guess because it kind of blows their narrative in the water, but they've got so many other problems beside. And I can only hope this time that the jury finds her not guilty, flat out. And then maybe the Commonwealth could prosecute the real killers. Also, anytime the FBI wants to get involved, it'll be fine. So, yeah. So that will bring us to the end of the stream, I guess. That was fun. I had fun. So are there any other stories that are getting your attention right now, or any other things that I need to cover that would make for good stories? I might be able to squeeze in one more live stream today. It's only 5 o'clock my time. I need a break, but I might be able to do a stream in a couple hours. Is there anything else that catches your attention or you want to hear more about? Oh, I saw a great Twitter thread on this. I don't know if I want to do a separate stream on it because I'm not sure what I want to say about it, but I'll pull it up and discuss it with you while you guys are thinking about what I want to talk about. So let me pull up this thread real fast because I thought it was interesting. If I can find it. Okay. All right. So this is this from Senator Mike Lee? Yes, it is. All right. So this thread is from Senator Mike Lee, senator from Utah, who is, as far as I'm concerned, very knowledgeable on the Constitution and pretty smart guy. And he had this pretty interesting little thread. He said, what are letters of marque and reprisal? And how could they be? I'm like, based. And we're going old school, man. Letters of marque and reprisal? Holy shit. Letters of marque and reprisal are government-issued commissions that authorize private citizens, that is, privateers, to perform acts that otherwise would be considered privacy, like attacking enemy ships during wartime. Privateers are rewarded with a cut of the loot they bring home. So it's a way to make private people into an army or a navy, as the case may be. And basically, like, they do it themselves and they get paid based on what they capture. They keep what they kill. They keep what they kill. So it's a way for the king or sovereign to have people do arm stuff and doesn't have to pay them. So that's a pretty nice bonus. So that's pretty cool. The Constitution authorizes these commissions in Article 1, Section 8, giving Congress the power to grant letters of marque and reprisal. It sure does. It sure does say that in the Constitution. While Congress hasn't issued one in a century, of course it's still there. We could issue it now. That'd be cool. Using letters of marque could be novel, but effective response to unique threats posed by drug cartels, especially in response to threats by cartels to target U.S. planes returning illegal immigrants. Yeah, right. And I have no particular problem saying that drug cartels are pirates. You know, no particular problem saying they're pirates, which means that I get to break out one of those wonderful Latin terms. I get to break out one of those wonderful Latin terms from Rome, which I suppose was implied by saying it's Latin. Which means that we can put the pirates and the drug cartel into this category of hostis humani generis. Hostis humani generis. The enemy of all mankind. Universal enemies. Universal enemies. Entitled to protection of no law. Like pirates, right? This is what the Romans invented. Like they invented this concept. It's like, well, how do we fight the pirates when they're not in our territory? How do we fight the pirates when they're not within our borders? And Rome solved this problem by saying it doesn't matter. They're universal enemies, so our jurisdiction is everywhere. So I was like, okay, well, that solves that problem. So you got that really old concept, and we declare them to be hostis humani generis, universal enemies, and that means that we can attack them anywhere. Great. Moving on. How could this be applied? Congress could issue letters of marque and reprisal authorizing private security firms or specialized trained civilians to intercept drug cartels, particularly those involving drug treatments. You could focus on disrupting supply lines, capturing high-value targets, or seizing assets like boats, vehicles, cash, gold, or equipment using the activity. I mean, that makes sense. That all makes sense to me. The advantages are the private entities operate with more agility than the government. The cost would reduce the financial burden on the taxpayer, as privateers only receive a cut of what they recover and return to the U.S. So it's a bounty, right? It's a bounty. So unlike us paying for a navy, it's a bounty. You kill it, you keep some money, we keep some money. You have the protection of the sovereign, right? You have the protection of the sovereign by saying you're acting on our behalf. So you're covered by our law. So as long as you get back here, you're safe. The use of letters of marque and reprisal will undoubtedly draw criticism, especially from those inclined to elevate abstract, often incoherent principles of what they deem international law. But as I said, right, you don't actually have to worry about that, because we can just do some old school international law shit. We can go back to, I think it might literally be the oldest international law. I don't know if there's law older than that. It might be, but I don't know. Damn. I mean, you're going as far back in international law as you want to get when you're breaking out phrases like hostis humani generis, right? So like, how deep in international law do you want to go? How about to the beginning? It's like, so I think figuring out how to solve international law would not be a problem. Dismissing the possible use of marques to combat Mexican drug cartels, either on the basis of international law, which incidentally I don't think is a problem, overlooks clear and present threat. This could prove to be an effective alternative to war. We have no desire to go to war with our southern neighbor. Also, that means it's like, as far as we're concerned, we're not going to war with you, right? Again, it's the same concept, right? This is the concept of hostis humani generis. It's like, we're not going to war with you. Because they're an enemy of all mankind, they're not protected by any country's law. So even though we entered your borders, we entered your borders for the purpose of killing the pirate, who's not protected by any law. So it means that we're not declaring war on you, even though we entered your territory for the purpose of it. So, I mean, it's some old school concepts, but hey, you got it, man, right? It's some old school concepts, but you got it, man. Marque is pronounced Mac. I'm sticking with letter of marque. I'm not ready to accept this in my life right now. Letters of marque and reprisal have worked well for the U.S. and countless countries in the past. We'd be wrong to not consider using them against the cartel. Let's go. Please share this if you idea and like if you want to see more posts about this. I'm happy with that idea. I'm happy with it. Let's go way old school. Let's go way old school and issue some letters of marque, man, and reprisal. You are a universal enemy. Go get them. Yeah, it's exactly how we deal with pirates. So I like that. I like that very much. What about when Trump offered buyouts to near federal workers? I don't know anything about that, but that sounds pretty based. I'm saying Mackey. You've watched too much DS9. I'm not saying Mackey. I'm saying Marquis. So it's going to happen? I don't know. It could happen. I don't know. Congress has to do it. Congress has to issue it. And Congress is pretty, divided right now. So I don't know that Congress is in a desperate attempt to do it. But I like the idea. I think it's pretty badass. I like the idea. It's pretty cool. It's pretty cool. It's Mark. Fine. Letters of mark. That just sounds wrong. Sounds wrong. Letters of mark. Sounds wrong. Do I have to pronounce it right? Also, incidentally, the English language is subject to change over time. Maybe it has a new exciting pronunciation now. Maybe the pronunciation has changed. Maybe I changed it. English isn't prescriptive, it's descriptive. I do what I want. No one has said the word in 100 years. How can I possibly be wrong? Of course it sounds wrong. It's French. Yeah, 100%. Oh, Lord. If someone said letter of mark, I wouldn't know what they were talking about. I would not know what they're talking about. So I'll tell you what, the pirates can tell us how to pronounce it. I'll let the pirates figure out how to pronounce it. That sounds fun. Opinion on Natalie Cochran murder trial. I don't know anything about that. What is a Natalie Cochran murder trial? Let me Google it real fast and see if I know anything, because the name doesn't strike a bell. What is a Natalie Cochran murder trial? Okay, apparently, according to Court TV, a pharmacist who pled guilty to running a Ponzi scheme that defrauded millions of people is standing trial on charges he murdered her husband. Natalie Cochran is charged with first-degree murder in the death of Michael Cochran, to whom she'd been married for 19 years. At the time of Michael's death, Natalie was running a Ponzi scheme that defrauded investors. She pled guilty to wire fraud and was sentenced to 135 months in prison. Natalie was originally indicted on murder charges in November 2021, but the charges were dismissed at the request of the prosecutor because they wanted to exhume the body and conduct further testing, and then recharged. I don't know anything about this case. I don't think I've ever heard about this case before. So I have no opinion. Yeah, I don't think I know that one. Marvin CZ, thank you for the 20 gift memberships. It is appreciated. Well, my friends, I think I'm going to go ahead and sign off for now. I've seen the Pirates of the Caribbean. I think I've seen like most of her, if not all of them. Did they use letters of mark or marquee in Pirates of the Caribbean? If so, I don't remember them being referred to by that name. I might have to catch up and rewatch the movies. I don't know. Miss Mandy Reacts. How are you doing, Mandy? It's been a while, I think, since I've seen you, or at least I don't remember seeing your name. Are you doing okay? Oh, by the way, for those of you who are curious, my mother's doing much better, by the way. I think she was discharged from the hospital today. I tried calling her earlier, but she didn't pick up. So I'm going to try to call her as soon as I'm done here. So see what she's doing. Yes, and they pronounced it Mark? Okay. I don't remember from the movie. I'll take your word for it. Although I think you're trying to mislead me. I think I'm being punked by MG Law. I'm not sure why, but I think I'm being punked. So anyways, I'm going to sign off for now, and I will catch up with you later. I hope all is well for now. Cheers, my friends, for now, and goodbye.